seat. I've already tried my persuasive talents in bringing you close to the front of the room, but I failed utterly. I'm Judy O'Brien. I am the pro bono partner here at Sutherland, Asbill, and Brennan. And just on behalf of the firm, I wanted to welcome you here today for the training. We face, in coming here for this training, an adventure of crossing one of the great divides in the legal profession. That is the divide between civil and criminal. And I don't know about the rest of you, but it is a precipice that I venture over with care, since it's so different from what we do. We are pleased to host you today in this Elbert P. Tuttle courtroom. Judge Tuttle was one of the founders of our firm, and he, of course, has continued to inspire all of us at Sutherland with his pro bono efforts and his contribution to justice in the United States. One of the areas in which he took pro bono case was in the area of habeas corpus, and he had, of course, a decision that went to the United States Supreme Court, the Johnson v. Zerbt case, establishing the right to counsel in federal criminal cases. So it's fitting that we should host this event here in the Tuttle courtroom, and I hope that all of your if your comfort needs are taken care of. There's food back there, there'll be coffee and soft drinks. And I just welcome you today and turn it over to Ryan Cavan now.
Thank you, Judy. I appreciate it. I'm Ryan Cavan. I'm currently the president of the State Bar of Georgia, and I come here with a great deal of pleasure and pride with what you are doing here. And let me start off with thank you for being here. Thank you and thank your firms for your participation in this much needed program. Your presence here is an important step forward in the efforts of the Standard Council to assure indigent defendants in criminal matters that they're going to get adequate representation, proper representation. And this is so important. Funding, as you know, the biggest issue, both of our courts, our indigent defense program and the like, the budget is, the monies just are small this year, and they're cutting, and you are helping to fill that void. I would be remiss if I didn't thank Judy, Kervin, Rocco, and Sutherland, the Sutherland firm, for putting this on here, allowing us to use these facilities, and their support. The Sutherland firm, and not to say that your firms, because the fact that you're here shows the interest of your firms in pro bono, but Sutherland just is everywhere on its pro bono work, and it is much appreciated by the State Bar and personally by me for things that we are trying to initiate this year and things that we are trying to promote. I also want to thank our governor, Sonny Perdue, and members of his office, his executive council, Nels Peterson and Ryan Teague, for this initiative, this training program. They made the phone calls, physically made phone calls to your partners, trying to get some support. And at that first meeting, it was gratifying to walk in and to see the firms represented at the table, ready to come forward. Further, this wouldn't happen without the efforts of the director of the Standards Council, Matt Crawford. Jim Stokes is here this morning on behalf of the council. Mary McCall Cash, and then the likes of Tricia McCann and Larry Schneider. I thank you. I encourage you on this. And one thing you might say, well, Kevin, you do civil work. How do you know about this stuff? What do you know? Why do you have any interest? I had the pleasure of having essentially two careers in my law practice. And I spent about 16, 17 years doing criminal defense work. I prosecuted for a couple of years in DeKalb. I was a special federal prosecutor on the heroin task force. but I did criminal defense work. And the beginning, I was about 4 months out of law school when then Judge Jack Etheridge, Superior Court Judge, I'd gone down to get a temporary hearing set on a divorce case, and he said, go get a cup of coffee and come back and see me. And he appointed me to a murder case. 4 months out of law school. Now, they say lawyers don't talk about cases unless they win them. I won a special plea of insanity in the case. We defeated the charges. My client ended up dying in an institution. But it did whet my appetite. Over the years, I have been involved both with paid clients and on pro bono side. My former firm, Gambrell and Stoltz, there were about 5 or 6 of us over there that joined in and worked for about 12 years on a capital case of appeal. And we had the pleasure, again, of getting a remand on an issue. Unfortunately, got in December, the Kim McMeekin case, but unfortunately, right after the decision came down, our client passed away, not by virtue of the state, but by health issues. And so, the one thing I want to tell you is that working with these clients is going to be different than working with your civil clients. You've got corporations, you've got entities, you're going to be dealing with real, live, breathing people, blood-flowing people. These are real people. It's going to be totally different. You are going to find in that not only some gratification, I think you're going to find some fun in the work. I think it's a great way to do it. It's a great learning tool. I've got one person sitting in the back here, and again, we go back 100 years, Jim Bonner, who has been incredible in his efforts in this. But again, welcome, and thank all of you for being here today.
Good morning. I'm Jim Stokes. I'm the Director of the Conflicts Division for the Georgia Public Defender Standards Council. And I too wanted to welcome you all and thank you for being here on behalf of the Standards Council. It's listening to the president of our bar for people who do criminal defense work. You can see how this kind of effort would come forward with his experience and his noted passion for doing this kind of work in his own practice. We appreciate your words regarding that. And we all have to thank Sutherland, the state bar. There have been various judges. Obviously, the governor's office has been very involved. The members of our staff, Mary McCall Cash and Trish McCann, have been integral in putting this together as well. Jiminy Rogers is here, and you'll probably see her around. She's the director of our appellate division at the Public Defender Standards Council. But thank you all for your interest and, first of all, your willingness to do this kind of work. I agree with Brian Cabin here that I think you'll find it interesting. I've been practicing about 16 years, doing mostly criminal defense and private practice, although for the last near 2 years I've been working either with Georgia Capital Defender or as the director of the Standards Council. I still defend death penalty cases and other various cases around the state. Also have been in the legislature for a number of years, sort of found that politics and defending death penalty cases, representing ex-urban areas and defending death penalty cases didn't necessarily coincide with political action committees really wanting to give a lot of money to your campaign. But anyhow, that being said, we appreciate you being here, and we expect that you'll take away from this some knowledge and maybe some confidence that you can actually handle this work. I know that there's been some trepidation from people that they don't feel like they have any experience in this area. But as you heard, I don't know that Mr. Cabin's experience in 4 months out handling a murder case and getting a good result is the norm. But you all can take comfort in that fact. I'm sure that you all are fine legal scholars, and a lot of you probably law review and have an interest in studying law. I think that we'll try to offer you all the the assistance that we can once you undertake these cases from our office and certainly from Jim and Eek's office, which is down in Peachtree Center. So again, thank you all for being here. I hope that you'll find this informative, and please contact me once you're ready to begin work. We're ready for you. We need the assistance given our budgetary constraints, and we really appreciate your interest and look forward to your efforts. Thank you.
To help you, as Judy said, bridge that precipice between civil and criminal law, we have a panel up this morning that will take you through the nuts and bolts of appeal. This is something for those of you who practice civil law. Criminal law, as you already know, is very different from civil law, and the criminal appellate process is somewhat different. And we'll get more into the substantive component of that, but to help you, we're going to bring forth our very distinguished panel, which will include, as you can see on your agenda, Robert Hurst, who is a CPD, Circuit Public Defender of the highest quality from the Ogeechee Judicial Circuit. You have a bio that was handed to you with your packet, so I'd just like to touch on some of those things that are mentioned. Robert has been a CPD, Circuit Public Defender, since 2004, and he has extensive experience in working with appeals. He's going to be facilitating the panel that has two other fine appellate scholars, Chris McFadden, who, as the bio says, wrote the book on appellate practice, and you will be well inclined to take a look at that as you go through. Always follow the rules. That's one thing about appellate practice, as you know, follow the rules. And we also have Tom Stubbs, who's done extensive work, successful work at the Court of Appeals and at the Supreme Court. And now I ask them all to come up, and we'll start with the nuts and bolts of appeals. We'll have them each present, and then you'll have time afterwards to ask questions. So with that, Robert, Tom, and Chris.
They have names on each side, so I know who I am too.
And I'd like to think I know who I am.
It's a search that's ongoing, and it's the search, or in your teenage years.
Good morning. My charge today is to give, at the outset of this, is to give you an overview of the appellate practice. Acknowledge that I'm talking to a lot of people who have got considerable appellate experience, I guess primarily in the civil area. And much or most of what I will say will be things you know very well. But I hope perhaps there'll be a few. I will be focusing on it from the criminal perspective. I hope even for you there will be some useful insights. So let's start from the very top. Why do we have appellate courts? What's the purpose of them? Georgia didn't always have appellate courts. A unique feature of its history is for about 60 years at the beginning of the Republic, the General Assembly had decided that it did not want a Court of Appeals or a Supreme Court. The creation of such a court was controversial for a long time. Governors urging the creation of an appellate court argued that without one, what we've got is simply tyranny. We've got Superior Court judges who are entirely supreme, appealable to no one, and that's not law, that's tyranny. Eventually that idea, of course, prevailed, and we now have our appellate courts. But it's important to understand that really is their function. I have spent the past couple of years on what seems like a continuous odyssey explaining what the appellate courts are, and particularly people who are terribly engaged in politics, but engaged primarily in defending the state of the nation from the depredations of the other party, and less interested in the judicial branch. In trying to get their attention, I have settled on the idea of invoking an ogre. What about this terrible judge who says, "Don't tell me the law, I am the law"? That's why we have appellate courts. And it really is why we have appellate courts. And the reason that I say that is to draw your attention to the fact that courts, that as you move up the system, the individual case begins to matter less. And the focus of the court is more on the system generally, the law generally, than the particular injustice in the case. Judge Dorothy Beasley, who was served many years on our Court of Appeals as one of the most distinguished judges there, used to say that the Court of Appeals is a processor of process, which is a truly soporific description. But her point was that the justice under law is really the charge of the trial courts. The charge of the appellate courts is really just to make sure that the rules are followed. And in the appellate courts, as you know, those of you who have done civil appeals, the focus is not so much on whether the result was right, but did the judge make a mistake in processing the process? Now, of course, that can include a mistake in determining that there's enough evidence to go to jury. But that's what brings us to standards of review. And standards of review are absolutely fundamental to any appeal because it's fundamental to the function of the appellate court. And they boil down to asking, what is it that we're challenging? What we want to be challenging is a judge's failure to comply with existing law. Because if we can characterize the issue that way, what we have is de novo review. We've got a law issue where the appellate court owes the trial court no deference. If we want to talk about facts, we need to understand we're dealing with what is, in essence, the summary judgment standard. All the disputes have to be deemed resolved against you in order to prevail on that basis. That's the any evidence rule. And if we're into discretionary decisions, we're in even more difficult straits because the standard of the abuse of discretion standard of review tends to be deferential in theory and almost prohibitive in fact, not entirely so, but it is very difficult to apply. And the basic analogy is similar to an ultimate boss and an immediate supervisor. An ultimate boss will not, if he's good at what he does, get involved in micromanaging every management decision that a mid-level immediate supervisor would handle. And the analysis is similar on the appellate court. The trial judge was there, he saw the people, he weighed the demeanors, he knew the intangibles. So that understanding of the role of the court as it relates to standards of review really should underlie everything that we do as appellate lawyers. Now, I want to shift now to talking about the process, and I'm just going to give a bird's eye view of what the process is. And as we do it, I'm going to break down more or less chronologically. And as I do, we'll be focusing on the role of the advocate. And I want to distinguish three roles that appellate advocates, appellate lawyers have in the process. Three functions that they have that are sort of distinct. One is that their responsibility is to preserve appellate jurisdiction. This is relatively simple, but obviously terribly critical. That means figuring out what the deadline is, and that's 30 days after final judgment in criminal context, that's 30 days after sentencing. Make sure that it's directly appealed, it almost always is in the appellate courts. But there are, for example, some authority would say the discretionary procedure, you have to ask the appellate court's permission before you have a full-blown appeal, applies in certain insanity defense cases. You also have to determine that you do have a final judgment, which obviously, if the defendant has been sentenced, that's not a problem. But exceptions to finality exist in our system, and they apply in criminal cases in the case of double jeopardy. And they apply in cases of violation of the right to a speedy trial. There's an exception where those are immediately appealable under what's called the collateral order doctrine. Now, in terms of preserving error, there are basically three things you can do, two things you can do. You can file the appeal. Obviously, not timely done, that invokes appellate jurisdiction. The other thing you can do is file a timely post-judgment motion. And under Georgia law, which is different from the federal law, there are three post-judgment motions that preserve your appeal rights. Those who motion for new trial, motion for judgment notwithstanding the verdict, and motion in arrest to judgment. Motion for new trial is probably the king of the three. So I'll address the other two briefly. JNOV, motion for judgment notwithstanding the verdict, is essentially summary judgment part 2, part 3. And it applies essentially the same standard. Motions for judgment notwithstanding the verdict are not available in criminal cases, only civil cases. In criminal cases, the available remedy is a motion in arrest of judgment, which serves a somewhat similar function, but actually resembles the old demurrer practice more than it resembles Civil Practice Act summary judgment practice. And the idea is that you have to be able to say, yeah, well, it says in the indictment, I did that, but that's not enough to convict me. So it's an important remedy that rarely applies. The one that applies almost always is the motion for new trial. Now, why do you file a motion for new trial? You just got convicted, the client and the trial judge are probably going to tell you that, their sense of demeanor of the trial judge as to a motion for new trial is in fact chance. Nevertheless, you almost always want to file a motion for new trial. For one thing, it's another bite at the apple. I view it as an opportunity to present to the trial judge a preview of my arguments on appeal, and to give that judge an opportunity to be persuaded by the arguments rather than passing the buck upstairs. In addition, one should be mindful that the trial judge has authority at the new trial stage, but the appellate courts do not. It goes back to Judge Beasley's observation about justice being in the hands of the trial court and the appellate court being a somewhat more arid and limited role. The trial judge is the 13th juror. He or she has the authority to withhold consent from the verdict, and if they withhold consent, they have an unlimited right on that basis to grant at least one new trial. The case law says if they keep doing it, they're entitled to less deference, but I've actually never, I've seen one case where the judge is doing that. It's not very likely. The other reasons are that you can add to the record at the new trial stage. One thing you can do at that stage is you can add newly discovered evidence. This is, again, sort of a theoretical option, although one certainly should be aware of it. There is case law in Georgia that says if you've got newly discovered evidence, you can go back to the trial court and file a motion saying, my gosh, look, I'm accused of murdering this person. Well, here's Joe. Here he is. Here's the guy I'm supposed to kill. And the case law says that's sufficient. And the case law says pretty much nothing else is. There's a case called Dick against State that lists 6 or 7 criteria. They basically boil down to you have to have a really, really good reason for not having presented it before, and it has to be really, really compelling. And in practice, those provisions pretty much are unlimited license to always deny the motion. But the remedy exists, and in an appropriate case, it ought to be invoked. The function of a new trial motion that is, I'm sorry, they're just so unique that the really important function of the evidence receiving power of the new trial motion is ineffective assistance, and there it is key. And I should just mention parenthetically that one of the other constraints on the appellate courts is they have no power to hear evidence. If it develops that evidence has to be presented to them, they've got to somehow get rid of the case, get it sent it down to somebody else, so that evidence can be heard and brought up. With respect to ineffective assistance, it is now pretty much mandated upon at the direct appeal stage. The rule is that you have to assert it at the first opportunity, and if you, having asserted it, you've got to assert it all, or you've waived anything that you haven't asserted. In order to effectively argue ineffective assistance, it is absolutely mandatory to bring up opposing counsel, bring up trial counsel, and hopefully get them to say, no, that wasn't strategy, I just missed the issue, it was my mistake. If they can say that truthfully, you know, you've got the key obstacle to an ineffective assistance claim overcome. Unfortunately, if the case law, it seems to be eager, seems to invite trial counsels who have made a mistake to say, well, there was some strategy there. And if they say that, however improbable, they will be believed. And if appellate counsel doesn't bring trial counsel into the trial hearing and doesn't get them to admit that there was a strategy, that there was no strategy behind some omission, then the case law has invited and encouraged the trial courts to make something up. And however improbable and unlikely this supposed strategy might be, it will be deemed acceptable by the appellate courts in practice. So it's necessary to get trial counsel, admit ineffectiveness if they will. If they're going to invoke a strategy, to be prepared to cross-examine them vigorously on what is that strategy, why does it make sense, why would anybody ever do that? Maybe, just maybe, the court won't blindly accept the assertion of some sort of strategy. Once the motion is ruled on, or the motion is denied, the appeal clock starts again, 30 days to file the notice of appeal. In the course of filing a notice of appeal, you've got to figure out which court to file it in. That basically is the Supreme Court's little red wagon. It is just a division of labor, but it is a division of labor in the state constitution, so the words must be labored over in great pain. However, if we get it wrong, it just means the case gets removed. So when in doubt, put it in the Supreme Court, so it can only bounce once. In criminal cases, it's pretty simple. If it's murder, it's the Supreme Court, everything else goes to the Court of Appeals. The notice of appeal is a statutory form. It's at the end of the Civil Practice Act, and you just sort of fill it out. And somewhere along the line, I think not in this part, I want to talk a little bit about the function of the various parts of the notice of appeal. Once the notice of appeal is filed, the case shifts into the second of the three responsibilities of appellate counsel. And this is one that really is best handled by an able paralegal or legal assistant. And that is shepherding the case up administratively. I'm going to talk about the civil requirements because the criminal requirements are just, in an indigent case, are just a sort of simplification of that. In order to understand this responsibility of getting your case out there and not getting it dismissed for delay in perfecting the record, it's necessary to understand the distinction between the record and the transcript and the rest of the record. The transcript is part of the record. A notice of appeal is followed with the clerk of the court, and it is in effect a direction to the clerk of the court to get the transcript ready. However, it is not noticed to the court reporter. You have to notify the court reporter separately and informally, and the uniform Superior Court rules and state court rules require that the court reporter be engaged before the notice is filed. Now, if you're up against the jurisdictional deadline, the heck with the rule, but at least make the initial phone call to the court reporter. It's hard to imagine a circumstance where you don't have time to do that. At the new trial stage, there's a requirement, if you don't already have the transcript of the new trial stage, there's a requirement while the case is pending on appeal and sort of in limbo between the trial court and the appellate court. That's the purpose here. When you file a motion in the trial court still has jurisdiction and responsibility to manage the case. When during the time the notice of appeal is filed and the notice of document is issued by the appellate court, the case is sort of in limbo. Supersedious is to some extent attached, limiting the trial court's authority over the case. The case hasn't gotten to the appellate court doesn't even know about it yet. So a case could just fall between the cracks and entirely disappear. So for that reason, the law imposes on the appellate certain responsibilities to make sure that it doesn't fall between the cracks. What those responsibilities are to order the transcript, make an arrangement with the court reporter, and make sure the court reporter does her job in 30 days. It's almost always true. And what that means in practice is, as the court reporter, again, if you don't have a transcript before the notice is filed, are you going to be able to get the transcript done in 30 days, or do you need an extension? Apply to the judge for an extension. The statute makes it mandatory. Follow up with the court reporter, make sure that when the extension expires, when the initial extension expires, make sure they're going to meet that extended deadline, and not get another extension. And all this is, it's in the nature of you applying to the court for extension, but really all it is documenting that you're following up with the court reporter and things get dropped. Another thing is paying the clerk. Once the notice of appeal is filed, the clerk, their statutory deadlines will get on the trial court clerks. They are meaningless. The trial court clerks get these done as quickly as they can get them done. Sometimes, particularly in Fulton County, that's much longer than 30 days. But their requirement is to send you a bill, and the statute directs them to send it out by certified mail. You've got to pay that bill in 20 days. If you don't pay that bill in 20 days, you are in the gray area that gets darker every second, where the other side has the ability to dismiss the case on the basis that there's been no effective appeal. Now, these things are unlikely to be problems in the criminal context, because all this means is that, ultimately, I guess this would mean that the case, the appeal would be dismissed. The appellate lawyer would be drummed out of the case for ineffectiveness, and somebody would have to come back in and assert through the right to effective assistance of counsel the right to an out-of-time appeal. But it's that area that you don't want to get into. In this program, we're talking about indigence, so we'll be making the appropriate filings with the court just to demonstrate that this is a wanted case, that this is an indigent defendant, and that the fees and the cost of the transcript are waived.
Chris, while you're right there, can I ask a question? If a appellate lawyer, predecessor appellate lawyer, has missed the deadline for filing a notice of appeal, how automatic is it that the court will find that that is sufficiently negligent for an ineffective assistance of counsel claim to allow an out-of-time appeal?
Pretty automatic, but not completely. The determination the court has to make is whose fault it is. If it's the client's fault, the client's determination not to appeal, the appeal rate dies. If it's the lawyer who needs to be hung out to dry, then the lawyer will be duly hung out to dry, and the client will be given another opportunity to proceed. Once the record is completed in the trial court, it gets sent up the hill, as they say, in Fulton County, it's sent to the appellate court. That court will issue a notice of docketing, and then it will say that your brief is due in 20 days. At that point, the focus becomes on what we're really trying to do, which is advocacy, preparation of a brief, preparation and enumeration of errors, and the Court of Appeals, the preparation of a request for oral argument. With respect to just talking about the overview here, it's important to keep in mind that the enumeration of errors is sort of a semi-jurisdictional document. They used to require a separate enumeration of errors to be filed with the briefs. They now just require that it be part of the briefs. But it is binding on the parties in the court in terms of framing the issues. Issues that are not enumerated in the initial brief are waived. There had been for many years some confusion. The Court of Appeals had overcomplicated the idea of enumeration of errors and were throwing issues out because enumerations were muddied together, and they didn't think that was right. But the Supreme Court has clarified that about 10 years ago. And this is a distinction I want to credit to a former partner of this firm, because I've been aware of it for years but haven't been able to clearly articulate it. Teresa Roseborough explains very elegantly. In the federal system, we've got issue-based briefs. At the trial level, the state level, We've got error-based briefing. Enumeration of errors are exercises of power by the trial court. The judge denied this motion, he granted that one. She gave this charge, she didn't give that charge. At the federal level, what are the issues? You know, does this crime merge with that crime? Is evidence of this sort admissible?
Can I ask a question?
Yes.
Yeah, if I understood it correctly, after the transcript is completed, there's, at some fairly short time after that, there's a notice of docketing, and then you have 20 days to file your brief. So it sounds to me like from the time you get a complete transcript, you have maybe 30 days or so before you have to file your brief. Is that about right? And if so, how do you go through a lengthy transcript and spot all the errors and write a decent brief in that short period of time?
Well, not magic. I'm going to add, there are two levels of your question. The technical answer is pretty much so, but not exactly. First, there has to be a transcript and the record. So it's possible that there will be some delay. The transcript is ready, but the record is not. But the critical point is when do you have time to read the transcript and to digest the transcript, is what we're talking about a little bit. And the answer to that, and I should have mentioned it in the process, is another reason you file a new trial motion, is that it's at the new trial stage. My practice, normally when you file a motion for new trial, you do not have a transcript. Normally, the court reporter will not be able to get you a transcript within 30 days, and if they can get it within 30 days, it would be at the very end of that period. So what one can do is file in the trial court what I call a skeletal motion for new trial. There is a form for the motion for new trial in the Appellate Practice Act at the end of the statute, and it gives a couple of suggested areas and then a recitation of what's called the general grounds. The evidence, the conviction is contrary to the evidence, contrary to the great weight of the evidence. File that, file a Rule 9 form, file a letter to the trial judge stating we need additional time to prepare the transcript. Please hold off on the hearing until then. And in criminal cases, the court will almost always do that. So that is where, and I've had civil cases where the other side was pushing back and trying to get things to move faster. And even then, there's enough play in the system that if the court reporter is reasonably cooperative, there's time to get the transcript read. Normally in the criminal case, particularly if the defendant is in jail, the state leaves you alone. But you have as much time as you need to get the transcript read and your new trial motion prepared. So that's an excellent, important question. The answer is that the flexibility in the system for getting a transcript digested is at the trial stage. There's also a statutory example of enumerations for error of enumerations of error at the end of the Appellate Practice Act. Once the enumerations are articulated and proceeds to the briefing, I think at that point I'll step down and
Before you do, actually, to touch on the same question, why don't you tell them a little bit about, if you do request an extension of the time for your initial brief, how is that normally greeted by the Court of Appeals?
The rules of the Court of Appeals suggest that they are very strict with extensions for briefs. In fact, they are customarily pretty lenient, but lenient only to a certain extent. One can get an additional 20 days. I have seen people get 30 and maybe even 40. But beyond about 20 or 30 days and beyond the first request, they are going to get pretty strict. And it's important to keep in mind that the appellate courts have deadlines themselves. They're subject to something that's called a two-term rule, and we may go into the woods on that a little bit, but for present purposes, basically they've got 6 or 8 months, depending on where things fall in the calendar, to get their appellate decision out. So granting you an extension, they're cutting into their time to decide the case, and they're recognize that giving you that first 20 or 30 days is probably in their best interest because they'll get a better brief, but they can't accommodate you indefinitely. The way the trial court can. I mean, if the court reporter has got 3 murder cases before they can get to this transcript of some lesser crime or civil case, the trial judge has the discretion just to wait. The appellate court doesn't. It would ultimately, at some point, if for some reason there was a delay, they'd have to remand it down to avoid limited problems with the term. So, yes.
I think you were talking about the Court of Appeals and leniency with continuances. What about the Supreme Court?
Pretty much, thank you. The Supreme Court is pretty much the same. I think they're probably a little stricter in my experience about giving you more than 20 days. Court of Appeals on the line, sorry. Any other questions? Well, I think there's that. I'll let you take over as facilitator.
How many of you have handled an appeal before or participated in working on an appeal in your office? Okay. How many of you have done that in the context of a criminal case? Okay. What I want to do is give you kind of a step-by-step suggestions of what you need to do to get the case up to the appellate level. And these are not, I'm not nearly as smart as these guys, but I thought that kind of a practical step-by-step approach might be of some assistance. So if this is just too basic, forgive me. If I know public defenders at times I've been in the position where you try a case and lose, and you're also the appellate lawyer. That's a little bit easier because you know the posture of the case, because you're counsel for the defendant. But the flip side of that is probably the position that a lot of you will be in by participating with us, is somebody else tried the case and somebody else lost the case. You're in the position of being handed a file for an appeal that you had nothing to do with. You didn't have any participation in framing any of the issues at trial. You've got to pick it up cold, search for issues, and get it up on appeal. Okay? That can be a little intimidating. So the first step is this. Determine the status of the case. In my opinion, nobody cares what I think, especially my wife, but in my opinion, if you try the case and lose, if you're the trial counsel, I think the skeletal motion for new trial that Chris was talking about should be filed by trial counsel or it's malpractice. Now, that's my opinion. And what is important for you as appellate counsel is determine, first off, what is the posture of the case? Has the case been tried and lost? Presumably the defendant's they've had a verdict and sentence imposed, so that is the full judgment in a criminal case. At that point, the judgment's been entered. What you've got to decide as appellate counsel is more than likely you're not going to get an appellate file 2 weeks after the case is over. Usually you get it months later. And by that point, you need to determine, has the motion for a new trial been filed properly within 30 days? Or has somebody filed a notice of appeal, which changes the timelines considerably? Or has the trial lawyer for the defendant blown a deadline? That's important. I've had Jim Bono probably won't remember this, but several years back, I represented a guy in an armed robbery that had been tried by another lawyer. It had been tried twice. It was very convoluted. The guy was convicted and got 1 million years, and I was the appellate counsel. And I went ahead and did an amendment to the motion for a new trial and had a hearing, and it was denied. And then when it was time to go up to the Court of Appeals, the clerk from Bullitt County calls and says, "Where's the motion for new trial?" Now, in Bullitt County, there are one of two chances. Either one wasn't filed, or it was and she lost it. Well, nobody could ever file. You think I'm kidding? There are probably pleadings at her house. I'm not really exaggerating. But at that point, I realized that the guy's paid lawyer had tried the case, had lost the case, and said, all right, I'm done. Had not even filed a skeletal motion for new trial to protect the defendant's direct appeal rights. So your first job is to determine what is the posture of the case. If a deadline's been blown, as these guys talked about, then you consider a motion for out-of-time appeal, which is asking the trial court to give us the opportunity to go up on direct appeal. Most of my judges are lenient about that, but I have one judge in my circuit who's a pretty hardcore right-winger, and sometimes he'll deny the requests. And you know, that's pretty unfair to a defendant who's in jail or in prison. He can't do anything about what gets filed in the courthouse. So, determine that. In the usual case, the judgment's been entered and the trial counsel has filed a skeletal motion for new trial, so that appellate timeline is protected. The beauty of the motion for new trial is you've covered your 30 days, and the trial court usually barely knows they're even filed. And you're not on anybody's radar at that point. It buys you time, as the question was, it buys you the time to request the transcript, to do some of these other things I'm going to suggest. And then you're kind of in the position of directing when it comes up in the trial court for a hearing. In some cases, you can file a notice of appeal. The difference between a motion for new trial and a notice of appeal is you file the notice of appeal, as Chris indicated, jurisdiction gets involved, the trial court loses jurisdiction, and the timeline picks up enormously. It's easier to file a motion for new trial that gives you time to do the work that you need to do. Next thing I would do is, Cynthia.
You mentioned what to do if a motion for new trial was not filed, and if the court were to grant the out-of-town appeal, what do you do then?
What we do is, there is a case, and I cannot remember the name, that says if the court grants a motion for out-of-time appeal, then the defendant is permitted to pursue any post-conviction remedies, including a new trial. That's right. And I had a goofy burglary case in Screven County that's up at the Court of Appeals right now, where the lawyer who originally tried the case blew the motion for new trial. And the sad thing is there's a copy of it in his file, that was stamped file and timely, but the clerk couldn't find hers. I know, it's scary. I mean, we're worried about the law. I just want to make sure the record's there. But at that point, I filed a motion for new trial. The court granted it, and then I gave the court an order that says, basically, you're permitted to file a motion for new trial. I filed a motion for new trial at that point, and the timeline started all over again. When that was denied, I filed a notice of appeal and went up to the Court of Appeals.
So that's just so that's clear. If you get the permission to file an out-of-time appeal, that includes allowance for filing a motion for new trial right there.
That's a really good point.
That case is Ponder versus State, by the way.
That's right.
The one you're seeing.
That's Westlaw back there.
I would request the trial transcript. And one of the I think some of the mechanics that y'all will particularly have to concern yourself with, and when we request trial transcripts in my office budget pays for the transcript. You probably are going to have to get some direction from the appellate division as to whether or not your law firm has to pay for that or the appellate division will. That's just a practical idea. You want to get the transcript, and you want to order it pretty quickly, because there are some court reporters who take a long time to get you a transcript. There are some court reporters, we have ours, the Chief Judge's court reporter, who's going to retire in October. She gives you a trial transcript back in 30 days. She's just a master at it. And then we've got two others who take forever. So order a transcript as quickly as you can. If it's possible, I think it is helpful to get the trial lawyer's file. I mean, I can't imagine this happens very frequently, but perhaps the defendant gave the trial lawyer some evidence, like the names of 3 alibi witnesses the trial lawyer didn't bring to trial. I can't say that that happens all the time. But sometimes you'd be surprised. Or you look down and look in the file and maybe you realize trial lawyer wasn't all that prepared when he went to court. What I do is I try cases using 2 notebooks, a main trial notebook and a notebook dedicated to cross-examination of witnesses. And when I'm done, the contents of those trial notebooks go in the file, rubber banded together, so that if an appellate lawyer wants to say, I want to look at your trial file, I can say, here are my trial notebooks, so it's clear the work that I did. Then I would review the courthouse file. And I say that because it is important to review the courthouse file to see what's in it, and also to see what did trial counsel file. Or are there orders in there that may have something to do with an issue to be raised? Perhaps there was a pretrial hearing where they ruled against the defendant. There's a written order in place. That'd be nice to know. But in the courthouse file too, for example, maybe you review the transcript and you say, wow, the judge gave a bad charge on identification. Well, it'll matter if you go back and look at the trial file and trial counsel didn't submit written charges. Then that issue might not be preserved for appellate review. Or, I had this happen too. I thought the trial court gave an improper identification charge based on the Brodus decision that came out a few years ago. I was all hyped. I finally found an issue. Then you look in the courthouse file and counsel did submit written charges and included an erroneous charge that the trial court gave. So that sure changes whether or not that's the trial court error or counsel blew it. But those are the kind of things you can find out in the courthouse file. God forbid sometimes you find letters that your client wrote to the judge. Things like that are out there too. I had a case on appeal that the guy fired, our office represented him, the guy fired us. He tried his own case and lost. And then he writes and says, I want an appellate lawyer. And I picked up the case only to find out that he had filed all kinds of pro se stuff there. It was already at the Court of Appeals. And, now you know why my hair is white. So I had to ask for an extension from the Court of Appeals to submit the appellate brief, and I got a whopping 5-day extension. But I won the case. Not necessarily in order, file an entry of appearance. And that's really important, particularly in the position that you guys are going to be entering this business in, since you're not really connected to the trial lawyer necessarily. And in some instances, you might be entering an appearance in a case that's not even in your county. An entry of appearance is important because when a trial judge subjectively decides that this case has been sitting around here long enough and wants to set it down for a hearing, there's an entry of appearance in there. They know to send it to you. What you don't want is just take the file and not file your entry of appearance, because if they set that thing down for a hearing, you might not get notice of it. Once you get your transcript, basically what you're doing is issue spotting. And what I do sometimes is I'll go through a whole transcript and keep a separate list of possible issues to raise an appeal. Now, it may come down that I make a list of 10 things and go back later and say, well, 5 of them aren't really meritorious, but these other 5, you kind of narrow. But the first thing I think you do is issue spot. And one of the things that you need to be particularly concerned about is you can spot the issues, but were they preserved properly for appellate review? If they were, great, you can take it up on direct appeal. If they were blown, you might have an argument that trial counsel was ineffective for not preserving the issue for appellate review. I think I did an outline on preserving issues, some issues for appellate review that I think is on the CD that's been submitted. And I hate to say this, the only reason I did that was I reviewed the transcript of a case that one of my assistants tried where he blew the motion to suppress. So I put together an outline and distributed it to the staff. So there's a list of this is how you preserve this stuff for appellate review. It's important. And there's nothing better as an appellate lawyer to read a transcript from a very good trial lawyer who very carefully preserves things for appellate review, because it makes your job 5,000 times easier. All right, you've gotten the transcript, you've issue spotted, and then you've got to make a decision about, of those issues, which ones do I really want to raise? I've had some where, yeah, that's an issue, but you know what, I'm not going to win on it. And so, you kind of have to make the decision, do we narrow issues? Some defendants want you to raise 10 and 12 issues. I think the law is, and you guys who are a lot smarter than I am can remind me, I think the law is, a case called Jones versus Barnes from the Supreme Court of the United States that says basically, when you're the appellate counsel, it's your job, and you have the final determination about what legal issues to raise through the appellate process. So if you get a letter from somebody in prison that says, I want you to raise A, B, C, and D, you can legally say, I've looked at B and C and they're bullshit. So here are the issues I'm going to raise. I think, is that a proper statement of law?
Bullshit.
Okay. At that point, these are some practical points that I do. You've gotten the transcript, you've spotted your issues. Then you're going to put together an amendment to the motion for new trial. Now, you've already filed, remember, the skeletal general motion for new trial. The principal importance of which is it stops the appellate timeline. It gives you time to do the work you need to do. Well, now you've reviewed the transcript, you've got your issues, and what I do is I prepare usually it's first amendment to motion for new trial that sets out the separate enumerations and the legal issues I want to raise. And I am as detailed as possible in that amendment. That means argument citations of authority, but also citations to the record and to the transcript. In my opinion, you want to do it as carefully as you can because you've got that time to do that. And also the main advantage of the amendment is it's like a template for your appellate brief that when the notice of docketing comes down from the Court of Appeals to Supreme Court. You'd be surprised, we'll get to that in a second, but that docketing notice can come, and it'll stay 20 days, but it took 6 days to get to South Georgia. And so suddenly you've got to put together an appellate brief in 2 weeks and get it out in the mail. If you take your time and put the substance into this First Amendment, when that docketing notice comes, you can say, all right, I'm basically halfway there already. Okay? Does that make sense? Okay. Then get a hearing. Yes, sir.
Let me just interject something, Rob. That's what I do too. One of the other benefits of that thing is that, it may be months between eventually doing the brief and going through the motion for new trial and hearing and that sort of thing. And the most common beneficiary of that kind of specificity, I've always found is myself, because a month later when you go back and look at that, you might remember generally what the issue was, but it's handy to know that that you go and look at page 632 to 642, that's where it is, and parallel have a reference to some motion or something like that was filed. That's a more benefit to you than to anybody else. And it also serves, incidentally, one other thing too. This kind of specificity and frankly making the argument you're going to make at an early stage. About one of the few advantages people have as being the loser of a criminal case in the appellate on appeal is you kind of are firing the first shots. And a lot of times the issues are going to be defined the way you define them. If you define an issue with that kind of specificity and you locate it, in 10 pages in the record, well, it's not necessarily going to keep the other side from wandering off and changing the issue, because of something that happened on page 420. But it reduces the odds of them doing that. The chances are that they're going to look at the record, the same record that you're referring to, and that they're going to look at the same law you're referring to, and that the issues therefore are going to be presented more likely in the terms most favorable to you. Whereas if you're vague about it, and you give them a chance to read search through the entire transcript to figure out what you're talking about, and they find something that you'd rather they not have seen on page 420, that affects that particular issue, and suddenly your issue changes.
Right, I think it's, to me, it's important at that stage to be as specific as you can. I had a case from the Supreme Court a couple of months back where the issue was the voluntariness of a defendant's statement. And during oral argument, the district attorney was really seriously tap dancing. And he just kind of said, well, you know, under the totality of the circumstances. And Justice Melton looked at him and said, tell me on what page this, this, and this. And he tap danced some, and then I got up there. Cindy, you were there.
Oh, I was there, all right.
And then I got up there and said, and in my rebuttal, and said, look, I didn't drive 4.5 hours to read transcripts to you. But, and because I've been specific, I said on page 67, question, answer, question, answer. And then during the trial record, on this page, question, answer, and sat down. And his conviction was reversed. But, you know, getting that specific early gets you ready for that. In that case, yeah, I was that specific 6 months ago when we did the motion for new trial, okay? The next stage is get a hearing on the motion for new trial. Unless you've got psychotic trial judges, and I'm not saying they don't exist, usually, if you file a skeletal motion for new trial, the case will just sit until you take the active steps to get it moving. That's usual. It might happen, and this happened to me a couple of weeks back, you might get some order out of nowhere that says, we're going to have a hearing on this day from the court. That, to me, doesn't happen a lot. Usually it's the defense lawyer saying, I filed my amendment, I'm ready to move forward. And it might be that you file with your amendment a rule nisi. Does everybody know what a rule nisi is? Okay. That just said you get it and it gets filed and then notice goes to everybody, here's the hearing day. Or it might be like we do down where I am, you call the judge's office, talk to the secretary and say, I'm ready on that Al Canty motion for new trial. Okay, I'll set it down on this day. Okay, set down.